Good evening, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Got my transcripts. I'm going to go over some of them. Particular part, kind of close to the beginning. Before the trial, actually, it was in the pre-trial. And we're going to go over some comments that were made in regards to that trial and expose some of their BS. And so I've got in front of me, I think, 9 pages, 8 pages. And they're short pages. They're transcripts. So I actually crunch them down. It's only about 4 pages. But I want you guys to pay attention because this is starting at a point where I was giving them a really hard time about their jurisdiction and their enforcement. And I was asking them, I'm free to go then, correct? Am I free to go? And the court responded, not the prosecutor, but the court. If you step out of the courtroom, you will be arrested. Okay? So that right there, I asked if I'm free to go. They told me no. And from that point on, it's known I was under duress. I was told I was not free. I again asked, am I free to go? He reiterated, no, you are not. You are not accepting these, and this is at a time where I was trying to hand over documents to the court. Not the court clerk. The court clerk already had them. Okay, now I'm going to hand them from my hand to his hand, arm's length. And I'm going to hand them directly to that administrator. And they're telling me they're not going to accept the documents. So if you're not going to accept my documents, I don't have to accept yours. If I don't have to accept yours, am I free to go? That's how the issue came about. And it says you are not accepting these. And these are the 4 documents along with my birth certificate of live birth. Now, mind you, that certificate of live birth was an old one from 1998 being used in its 2016 trial, but it's still a financial instrument evidenced by the face. Wasn't authenticated or anything, but it did have the state seal. Okay? That now lies in evidence in that case. They are the holder of that title. They are, in fact, the trustee now. That is admitted into evidence. Comprehend that part. It's one thing I did do right. Along with the other 4 documents, age of majority, power of attorney, statutory declaration of the true name, and notice of foreign status. Those are the 4 documents with the certificate of live birth that I entered in here. Okay. It says you are not accepting these. And he said, I am not right now. We are addressing. I said, you have to accept these in order for me to continue on with business. Now, I spoke these words specifically. Why don't you lay them right here on this table, he says. No, you need to accept them. Okay? This is all offer and acceptance in formation of contract. We're going back and forth. Okay? I said, no, you have to accept them. Now his next comment is bring them up. Acceptance. Okay? He also, in accepting those documents, accepted the fact of my statement saying that you have to accept these in order for me to continue on with business. Very specific language. Defendant, per person, Mr. Lees, I seem to be short of a 1096 cover sheet. And I was handing out the 1096s, W-9s and stuff at this time. Along with the 3949A, which is what I call the snitch form on the prosecutor and the court system for a possibility that there seems to be fraud on the face of the record. This is what they put the protection order out on me for. Okay? They renew it each year. Now I want you guys to comprehend the pages that I'm reading and the fact that they admit my mental capacity within the statements. So they're already noting that I'm not insane in doing this stuff. Per person, Mr. Lies, I seem to be, they call it Lees, it's spelled Lies, I call him Mr. Lies. I seem to be short of a 1096 cover sheet, but I will get that to you. And then there's 1099, this is for Miss Wagner, that was a 39, and this is for so-and-so, and there's a fiduciary form for Mr. Moodhart. I called him Mr. Moodhart, his correct military capacity. And he said, please be seated, sir. Because I was going around handing them out, and people were taking them. Once he said, I will accept them and bring them here, and I started handing out all the documents. And they all just stood there like the robots. Okay. Comprehend. I didn't comprehend how much power I had in doing this stuff until after I looked through my transcripts. And I'm going to point some of this stuff out. So I went ahead and I grabbed my seat, and it says, now you understand that with respect to the charges of possession of controlled substance, third offense, you have a right to a trial by jury. Do you understand that, sir? No, I do not. I told you yesterday. I do not understand any of these proceedings because you're violating my rights continuously from point A to point B as we sit here today. Court, if you wish to proceed to a trial by, I cut them off. And it shows you the 2 dashes. In the transcripts, they'll show you where somebody cuts you off. Because the transcripts will stop and the next conversation will start. So I cut him off, and I said, I do not wish anything but to leave. Court, the law requires that you sign a written waiver of jury trial and that you confirm that waiver on the record. Lie number 1, show me the law. And actually, that's not even the lie number 1. That's just lie number 1 in this video. Okay, show me the law that says I have to sign anything. I've already proven you I can refuse to sign, and ain't shit you can do. Make me. Form the muscular contract, showing the agreement with my heart to do so. Says, and that you confirm that waiver on the record. Defendant, I refuse to sign. I do not wish to conduct business. All right, if you refuse to sign the written waiver of jury trial, we will be proceeding with a jury trial. And we will be doing that right now. So, you're saying that you're willing to conduct business against my wishes under the threat of arresting me if I do not. It's a very clear statement. Then he says, well, I'll make it more clear. If you disrupt our proceedings and continue to refuse to cooperate with us, providing you with a trial. So are they providing a service? Are they a service provider? Is that just admitting right there on the record they are providing a service in a trust operation? Think about this, people. You are first of all running the risk of being found in contempt, and contempt of what? Again, I interrupted. Contempt of what? Freedom of speech. Contempt of court and incarcerated. I do not want to go that route. Neither do I. I only wish to leave. Like I said, I'm here on special appearance to settle these matters. And I'm only here under duress because you threatened me with arrest. If you're not going to plead guilty, the court says, if you're not going to plead guilty, we will be proceeding with trial. I said, sir, I offered up my written plea of guilt at arraignment earlier with the Judge Callahan on record. and stated my name clearly, spelled it out, case sensitive, and was threatened with arrest for not participating. Then, when I offered up my written plea of guilt, I asked him, am I free to go? Because he would not accept it. He stated I was free to go. I left. He issued a warrant for my arrest, saying that I failed to appear. I find an inconsistency here with both judges saying the same thing. If you walk out, you will be a warrant will be issued for your arrest. This judge confirming that I will be arrested upon leaving the courtroom, after asking both of them if I am free to go. The one said yes, and then issued a warrant for my arrest for failure to appear. I have first-hand witness and video recording of it, as well as the judge admitting it in the warrant with his babblese. So, if you're not going to, I clearly spelled it out. Court comes back with, do you want to plead guilty? No, I do not wish to be here at all. Well, you are here. You people are violating, again, I responded back, you people are violating my rights. The court comes back, you are here, and I want you to settle yourself down, because right now we either proceed with a trial by jury in the other courtroom. Are we going to switch jurisdictions? We're going to move from this courtroom to another courtroom. That sounds like a change of venue. Are we going to have a different participating audience? Serious questions to ask in regards to how they proceed with things. Proceed with a trial by jury in the other courtroom, and you comply with the rules of court. I interrupted again. You'll see the 2 dashes where it shows I interrupted. I don't comply with anything I don't understand, sir. I let him know I don't comply with what I don't understand. I must first understand the mathematics before I can comply with the mathematics. Or you waive your right to a jury trial, and we'll proceed with that trial this afternoon when the witnesses are called to testify. I waive no rights. Court says, Mr. Lees, would you please step up? Mr. Lees complies. Court, and this is a waiver form. If you'd at least show it to Mr. Little, he can see what I'm referring to. Again, I reaffirmed, I waive no rights, and held my hands up. I waive no rights. I done told him I'm not signing. I am already convicted to that. You can't convict me to anything more. Think about it, people. The Iowa court comes back. The Iowa rules of criminal procedure provide that if you are waiving your right to jury trial, the waiver must be in writing and on the record. And what I'll do is begin. I do not waive any rights. I demand a trial by judge. If I want a trial by judge, just because I want to assert one right doesn't mean I have to give up another right. That is not the way the system works. That is not the way the law works. They'd like you to believe that's the way the system works, because that's their system. Says, all right, you're entitled to trial by jury. We'll give you, I understand that, but I demand my right to a trial by judge. Without a jury, all right. Listen, we've already talked about your lack of mental illness. Remember, we've already talked about your lack of mental illness, admitting that I am mentally competent. In, on, and for the record. And I have like I said, I've been in foster homes throughout much of my life. And once I was adopted, there were certain things that they wanted to classify and categorize and criminalize and staticize. And they put all kinds of things on that file. And every last one of them converts to the same thing. Mentally competent. Not once have I ever been committed as being actually insane. In fact, the one time they did want to test it, they sent me up for a 30-day evaluation, and the doctor came back after I took that MMPI in 2 weeks. And the doctor had authority to override the court ruling that said I was supposed to be there for 30 days because in his competent licensing, he said I was not subject to mental evaluation. He doesn't hold that jurisdiction. Says, and we are now asking whether you are demanding a trial by judge of your own free will and demanding a trial by judge instead of by jury. He let me know there, and I didn't comprehend this until after I'd read it several times, but he let me know right there that I was the one making the demands. If you are, this is me coming back, if you are going to force me through intimidation tactics to conduct business with you, I demand a trial by judge. The jury has no business in it, folks. Not until the judge hires them and pays them to be a juryman. Sounds like he's going to shred that case and sell it off to little bits and pieces and have people come up and testify, yeah, they invested. Yeah, wait till I show you some of that. Derek Gonzalez, you ought to be interested in watching that one when I pull that one out. I got a part of my transcript here, shows you how it was shredded. In my opinion, anyway. I can't say that for a fact. But according to the elements on the face of the record, that's the way I see it. So anyway, I waive no rights. And no one is forcing you to demand your trial by judge. No one's forcing you to demand it. And he keeps asking. Is that correct? Correct. I responded appropriately. Yeah, nobody's forcing me to demand it. When in fact, I didn't know what the hell I was talking about because I didn't need a trial by judge. I needed the damn account settled. Balance to zero. Obligations discharged. And no matter how I tried to convey it, which you'll see in here, they didn't take it down as the proper notes. Notes. Symbols. Interpretation. Report. They didn't report it the same. And do you understand? However, I interrupted, let it state on the record and for the record that if you were to force me under threat of arrest with 2 officers with devices of detainment who have already shown that they will violate my rights without due process, I refuse to waive my rights and demand that if you're going to conduct these or this matter, I demand that you step up to your fiduciary duties and support and uphold my rights. Fiduciary duties, not commercial performance. Court comes back to, you understand at the trial we're a trial jury. I don't understand anything, I interrupted. Court, your trial would be before a trial of 12 members of the community who would be selected during the jury selection process. Do you comprehend what I'm saying? Now he says comprehend. I said, I don't comprehend any of these proceedings. Again, like I said, how many times do I have to tell you it's confusing because you're violating my rights. You have a fiduciary duty to uphold my rights. the court comes back, you would be allowed to participate in jury selection. Participate. And if you're representing yourself, you would actually engage in it. Participate as opposed to actually engage. Are the participants the ones that are investing? Are the ones engaging the ones obligated under performance? Think about this stuff, people. This is literal language. And again, who's representing themselves? Is he a party or is he engaging? Or is he both, a party and engaging? Is he the you? I don't represent myself, I interrupted. How can I do that? That's insanity. I'm simply me. Court, you could not be convicted without unanimous verdict of guilty by all 12 jurors. And if you proceed to a trial by judge and not a jury, the court alone will decide your guilt or innocence. Can the court come forward? If the court comes forward, is it the entourage of those who were obligated to perform in the procedures along the way from point A to point B? The court alone will decide your guilt or innocence. Well, if the court alone was to decide my guilt or innocence, how come it is not allowed to be put down as a guilty plea? And why is it they ask for not guilty instead of guilt or innocence? Either way, they leave you in the realm of guilty. Neither the court nor the state will in any way reward you for waiving your right to a jury trial. Oh. So if I don't waive it, is there a possible reward? I mean, if you violate it, is there a reward? Think about this stuff, people. You are refusing to sign a written waiver of jury trial. Is that correct, sir? Now remember, people, they just said that I'm mentally competent. Now, we've already discussed that issue. And I come back and he says, you are refusing to sign a written waiver of jury trial. Is that correct, sir? I come back, I waive no rights. I no longer consent to anything by signature or verbal commitment. Are you not, Miss Wagner, the executor of the CQV Trust? Are you not the trustee and I am the beneficiary? Court, I am directing the state not to answer the... And he got interrupted. But he first said that he is directing two rules, the state not to answer. Does he have the authority to tell the state not to answer? The state's the one that brought the damn claim. Now you're telling them to shut up? Who's the true authority here? Huh? I find that kind of inconsistent. Defendant, I give you authorization to do the accounting on this trust. I give you the authorization to do the accounting on this trust. I named myself the beneficiary. I let them know I am the beneficiary. And I gave them. See, they had the authorization and they didn't act upon it. A trust shall not fail for want of trustee. The beneficiary is deemed to be the true owner. So if the beneficiary is not benefiting from the trust and he's deemed to be the true owner, he thereto has the power of dismissing the trustee, not the case, not the account, you dismiss the trustee. And then you settle all accounts as the beneficiary, because it thereby collapses. If the trust is detrimental to the beneficiary, he has all rights. Period. Impunitive. Immutable. Because all trusts, the intent of which are to be beneficial. Notice, they never denied the trust. And as I take possession of my body, I collapse this trust, for it no longer has any value. It has no value to me. Period. And it's proven in, on, and for the record, it has zero intrinsic value. The court turns around, not the state, not the plaintiff, again, asserting some kind of authority, and asks me, "Are you under the influence of any alcohol or illegal drugs today, sir?" "No, sir." "Have you taken any medication in the last 48 hours? "No, sir." "Are you required to take medication?" "No, sir." "All right, so you're not under any directive. You know, nobody else is directing me like he's directing the state, huh? I'm not under his directives." "No, sir." So you're not under any directive from any physicians to take medication?" "No, sir. I was prescribed a Remeron to help aid in sleep. That I quit taking long ago. And it is not directed by any court order or anything. No signed papers, no contracts, nothing. I committed no crimes. And as I've stated in many documents that I've submitted to these courts on file in my case file, that I rescind my name for all these contracts. So again, I uttered it on the record. I rescinded my name for all these contracts, and I have a right to rescind the name as well as the signature. Again, I have superior authority over that name in any form. They can only copyright the data sheet that it's used in. Court comes back. Any further record that the state requests regarding the attempt by the court to confirm Mr. Little's waiver of his right to a jury trial? No, Your Honor. And sir, again, the written waiver form is in front of you on the counsel table. Are you able to read and write the English language? And I referred to the documents that I handed to him earlier, and I said, "Have you not seen my documents?" He asked me if I understood the English language after giving him some documents. I believe he understands those documents, and he better understand the language in them, because he's got them in his possession. Says, "Have you not seen my documents?" Court comes back, "And all these documents that I filed, have you just bothered not to notice them at all?" This is just a standard question that I'm required, and it's a standard answer. How can you ask a question like that when it's clear that I know the English language? The court comes back, "I've already indicated that before you can be convicted by a jury, the verdict must be unanimous." All 12 people. Why are we now talking about the jury trial again? I thought we were over the issue with the jury trial. I've already indicated that before you can be convicted before a jury, the verdict must be unanimous. All 12 people must agree as to whether you are guilty or not guilty. If you waive your right to a jury trial, the case will be tried before a judge, and that would be myself this afternoon, beginning this afternoon. I alone will decide whether you are guilty or not guilty. I will file a decision in writing which will be entitled Findings of Fact, Conclusions of Law, Decision, and Order. And I'll advise the state, are you making a lawful determination? Are you giving legal advice as a court? Are you giving legal advice as a judge sitting on a bench of a court? A private entity, in that fact. Private entity, I told you I copied my transcripts right here on the very first page, and I've got evidence. Judiciary Courts of the State of Iowa, Dunn's number 360706329. That is a 9-digit number given in lieu of cash. Pay attention to my videos lately, people. So, I'll advise the state that I have attempted to confirm for the record Mr. Little's demand for a trial to the court and not have a trial by jury. I'll advise the state that I have attempted to confirm for the record Mr. Little's demand for a trial to the court and not have a trial by jury. He is indicating he will not sign the written waiver form. And it is my intention to proceed with a non-jury trial, even though we do not have a signed written waiver of jury trial as is required by the rules of criminal procedure. Does that tell you, folks, that according to their criminal procedure, to proceed further, they need that signature? Did he proceed further without that signature? And is that requirement, his form? I have serious questions, people. And the answers are all right there. He said it was required, did he not? Did he just violate the requirement that actually applies to him that he said he would be presiding over? It is my intention to proceed with a non-jury trial, admitting both that it was his intent and that he was the participant. He was the obligation he was obliging himself to perform. I wonder where he gets his authority. Even though we do not have a signed written waiver, does the state have any objection to me making a finding that to the best of my ability I have determined that Mr. Little has made a knowing, voluntary, and intelligent waiver of his right to a trial by jury? I interrupted. I clearly stated on the record, I waive no rights. He interrupts me on the charge of possession of controlled substance, third offense. Miss Wagner, the prosecuting attorney, no, Your Honor. The court comes back, and the state agrees that we should proceed with a non-jury trial on that charge. Miss Wagner comes back, correct. I believe on multiple occasions Mr. Little has demanded his trial or his right to a trial by judge. Are they trying to now say that I can't make a competent decision? Or are they now trying to say that they can't make a competent determination? Because they stated I'm mentally sound. And you can see that I asked mentally sound questions. And you can see that they never gave a clear answer. Instead, tried to assert that I had to sign some form without any conclusion of law which he bases his finding of facts on. Where's the conclusion of that law? Where is the law that says I am required to sign? Where's the law that says I'm required to have an identification? If I'm not required to have an identification, and the identification is tied to a signature, then where's the law that says I have to have a signature? I don't know of any. He's a babbling idiot. And he proves it with his own statements. And there's not a damn thing he could do about me showing it out here in the public. You wanted to make such statements in public, and this is a public transcript, people. So it's not just a matter of me being privy to that proceeding. It was a public proceeding. They had public witnesses in there. It's public domain. So he goes on and says, on the charge of possession of controlled substance, third offense, when in fact it was sixth offense. But in statutory terms, they can only go up. Maximum enforcement is 3 offenses. They don't have any enforcement for a 4th, 5th, 6th. It doesn't get any steeper than third offense, so they just claim it as a third offense. Because that's how it's categorized. I believe on multiple occasions, court says, okay, then I will make that finding and find that there is a knowing, voluntary, and intelligent waiver of right to trial by jury. Again, he's saying that I waived my right to a trial by jury. I never stated any such thing. In fact, I stated the complete opposite all the way through. I waived no rights. And again, I assert, just because I assert a trial by judge doesn't mean I have to weigh out the rights. They're all there inherently. I can't give up one for another. And I'm not required to give up one for another. And therefore, your conclusion that I have to give up one right for another is bullshit. Bullshit. Lie. Propounded by Miss Wagner's belief. What time are the state's witnesses subpoenaed to appear this afternoon? Starting at 1:15, Your Honor. All right. Then we will reconvene this afternoon. Defendant, I'm here to settle these matters. Now, we cannot proceed to trial at this moment. This is the court's response. I'm here to settle these matters now. Court responds, we cannot proceed to trial at this moment because the state was under the impression that we would spend the morning selecting a jury. Really? This is new to you? I've been demanding all along a trial by judge? You confirmed it as a knowing, willing, and voluntary consent to do so? Or waiver of jury trial to do so? We cannot proceed to trial at this moment because the state was under the impression that we would spend the morning selecting a jury. All the while recognizing that I was demanding a trial by judge? But you wanted to play this circus thing about some giving up my right, waiving my right to a trial by jury? To avoid the fact that I was demanding? See, I get it now. I get it now. I do. Don't ever bring me into your courts. Says, we cannot proceed to trial at this moment because the state was under the impression that we would spend the morning selecting a jury. The companion charges that I referred to yesterday will also be presented to the court. Now, on the summons, the charge is marijuana with subsequent charges. So I said, you're speaking of the subsequent charges? Court says, no, I'm talking about interference with official acts, possession of drug paraphernalia. Correct. of which the invalid plates and registration was the initial stop, the original, the genuine contract. He interrupts me again. Operation without registration, which has never been signed, I interrupted, and the financial responsibility comes back with. Violation will also proceed this afternoon as non-jury trial. So those are all the companion charges that are listed as subsequent charges in the summons. Yet he just controverted what I was... You're speaking of the subsequent charges, which is all those 5 other charges that he just rattled off? And he said no. I'm talking about interference with official acts. Well, what's the difference between subsequent charges and companion charges then? I have some serious charges. Is there a marriage there? Is there a union of companions? Is there a mother and father, a husband and wife? Children per se? Parents? See, I get it now. And the financial responsibility, and you're not pleading guilty to any of those either. Is that correct, sir? No. Is that correct, sir? No. All right, anything else that's... See, it didn't matter that I didn't agree with him. He's asking, and the financial responsibility, are you not pleading guilty to any of those either? Is that correct? He just asked 2 questions. Are you not pleading guilty? Would refer or infer that you're pleading not guilty. No, that's not correct. I'm not pleading not guilty. Are you not pleading guilty to any of those either? No, I'm not pleading guilty either. I'm not making a plea. Didn't we just clarify what I was demanding? See how they babble? See, and I get it now. See, again, after looking over this, I see how they had me all spun too. Ain't gonna happen no more. And it's a curious thing. Like I mentioned, that DUNS number is a 9-digit number in lieu of cash. That obligor number. Can you see it? That obligor number, that's a 9-digit number too. They use 9-digit numbers in lieu of cash. Watch my previous videos, catch up, do some watching, and figure this out. Because they use that in lieu of cash. On this document, they labeled it as obligor, and then said it was a Social Security number without the hyphens. You cannot stylize it as a Social Security number by saying by putting it down without the hyphens. That's a lie. That's a falsification. That's a misrepresentation. Everything they do is false. It's all to spin you round. The merry-go-round. So let's go on a little bit further. The defendant comes back, all right, anything else that the state would like to make a record of at this time before we recess until 1:15 this afternoon? I spoke up. If you recess, that's called abandoning the bench. I want to settle this now, honorably. Miss Wagner interrupts. No, Your Honor. Court says, okay, without paying attention, we are in recess until 1:15 this afternoon. Even though Mr. Little has refused to communicate with Mr. Lies, I am requesting that Mr. Lies be available as standby counsel. I have appointed him as standby counsel. Okay, now, comprehend something. Let's name that trust, people. The judge gave a grant of power to Mr. Lies to stand in as trustee. The grantee granted the trustee in reference to a beneficiary. And that beneficiary was named in a court martial as Mr. Little. Not myself. Again, not myself. They will never identify myself. And of course that was entrusted to Mr. Lies. And it clearly says, I appointed. I, not we, or they, or have authority to appoint from somebody else. He says, I have appointed. It means it's already done. Really? And then recess happened. Coming back from recess, court, we are on the record, and again, this is case number State of Iowa versus Keith O. Little, not Mr. Little, Keith O. Little, upper lowercase. Yet the defendant is Keith Orland Little, all uppercase. Keith Orland Little, upper and lowercase. Keith O. Little, uppercase. Keith O. Little, upper and lowercase. Keith Little. All kinds of stuff going on here. Mr. Little, there's at least 8 different ways they have stylized this defendant. Never once agreeing that I am a party, subject, obligated, performing anything, or contracted to perform. We are also addressing in this non-jury proceeding SMCR 215190, which has complaints charging interference with official acts and possession of drug paraphernalia. STA 0147223, operating without registration. STA 0147224, violation of the financial responsibility law. Defendant broke in. I'd like the record. Court stopped me. Please, sir, do not interrupt me. I do not see a document that was filed this morning until after our earlier proceeding. It is a demand to recuse per Clearfield doctrine. I have reviewed that document, and I'm overruling the demand. See, he's recognizing my demand and saying he has a higher authority. Okay? I am overruling the demand to recuse and will be proceeding with our non-jury hearing. Again, our non-jury hearing. The waiver form that Mr. Little refused to sign this morning will be incorporated as part of the record as a court's exhibit. So he has entered in on and for the record a document that is required to have a signature in order to proceed without having the required signature, and then proceeded, proving in on and for the record that he violated his own rules of criminal procedure, that he is bound by, that he is the one that recognized. He's the one that uttered that in court. He's the one that directed the state. I said, could you state that again, please? The court comes back to waiver form. Written waiver of jury trial, which Mr. Little refused to sign. Objection, I should have said right there if I'd have known what I was doing. He said written. We know it's not a written, because it's not a written waiver. It's a typed out form that he wanted you to sign. He specifically called it a jury waiver form. It was already made up. It was already printed. And all they want is your signature. That's not a written form. It's a cursive form. Will be made part of the record as a court's exhibit. So now we have a defendant's exhibit, a plaintiff's exhibit, or state's exhibit, and now we have a court's exhibit. What's going on here, people? What kind of file keeping these people got? Huh? Huh? Serious questions. I want to know where this paperwork goes. Both ends, where it comes from and where it goes. I will point out as well that all of the issues, that means the original charge of possession of a controlled substance, third offense, as well as the other 4 simple misdemeanors. See, now he's saying simple misdemeanors. He's not calling them companion charges. He's calling them simple misdemeanors. Well, and then he also read them off as different STA this and SMCCS whatever this. Small claims civil as a criminal attachment or attached to a criminal suit. Come on. I'll tear these people up in court from now on. Question everything they write and make it so they're the ones that write it all. Hand me your documents. I'll tear them up. As well as the enhancement issue will be presented in one proceeding. The enhancement issue is the fact that it was third offense, actually 6th offense, and they were trying to give me some kind of habitual. Now, mind you, people, I want to speak real quickly here on the fact that, again, they appointed this Mr. Lees as standby counsel because when he came out to me before these proceedings as supposedly being assigned, appointed, whatever, and told me he was my standby counsel, I said, no, you're not. You say one word in that court in regards to myself, I will hold you liable. He didn't say one word in that courtroom. Not one word. You can read these transcripts. He did not say one word. Not until sentencing where the court asked his opinion on something. And it wasn't in regards to me. I was good with it. But the first 5 offenses, I had an attorney. And as I was trying to make points to this attorney, this public pretender, they would always look at me and go, shh, shh. This time I told him, no. You say one word in there in regards to myself, I'll hold you liable. I'll speak for myself. And now all of a sudden, despite even the enhancement issues, despite the fact this silly, goofy woman standing over there professing that I've got a criminal rap sheet this thick, and obviously I'm not going to listen to them when they hand down sentence, so they may as well hand down the most strict sentence they can. The judge looks at him and says, really, you suppose? You suppose? And at that point, at sentencing, I believe that judge knew and comprehended what kind of man he was up against, because if he sentenced me to the maximum penalty in prison, I'd have been teaching them guys in jail how to do this shit. I'm not going to stop. So consequently, instead of getting the max penalties of 2 years, my 60 days. 60 days in jail compared to 2 years, all the 5 previous offenses. And I did it in 47. And again, I walked out refusing to sign. Look me up. I got a rap sheet this thick. And all kinds of them sitting down there still unpaid. Supposedly I'm supposed to give them a drug eval, never gave them one. Supposedly I'm supposed to give them a DNA, never gave them one. Supposedly I've got thousands of dollars worth of fines down there I'm supposed to pay. Yet there's no warrants. And this goofy woman standing over there professing all of this is the one that continuously renews the protection order. Why do you suppose that is? So, we will not have the enhancement issue addressed at a later time, as we would if this were a jury trial. All issues will be presented. And Miss Wagner, are you ready at this time to present evidence? Yes, Your Honor. And so the trial began. I hope you guys paid attention, because I made some very valid points, and that was just a few pages of that document. That's 256 pages of a trial transcript, along with multiple pages of a couple other hearings, for a total of over 300 pages of documentation that they, quote, have certificates on, but can't authenticate. Amazing stuff, people. Pay attention. The videos that I've been putting out lately are hopefully going to bring you to a cleaner comprehension of what's going on. And like always, I'm going to post my other forum links. I keep telling you guys I could certainly use it. If you looked at my documents, you can see they're losing ink. They're not quite as dark as they're supposed to be, because I had to make my own homemade ink in order to print this document off. I could certainly use all kinds of things, so I'm going to include my PayPal link. Please hit the share button, or hit that button and share some love. In the meantime, it's going to have my other forums. Again, like this video here, it's all valid, pertinent, very important information that we all need to learn. So please keep hitting that share button on the information, the videos, the forum links. Share it all so everybody can have access to this. Okay, and remember, if it weren't for you guys, I wouldn't be doing this. I'll be coming back soon with another video on some more important parts in this document. Like I said, that Dun and Bradstreet number, that's right on the very first page of this document they gave me. The very first page. The title of the page is a Dun and Bradstreet supported by a Dun and Bradstreet number. So think about this stuff. And like I said, I'm going to be coming back with a video that I hope I can get through to Derek Gonzalez in regards to one of his prior videos a couple years ago, where he did a video about shredding the case. See, when they shred the case, they don't actually shred the case. Matter of fact, let me explain that to you real quick. What they actually do, people, is you will oftentimes walk into a convenience store and you will see signs that entrepreneurial young people will do. And what it does is it's got you'll see a little sign up there offering a service. And if you want to accept it, you tear a little piece off. You're going to tear a little piece off. You're going to get some information of his offer. You're going to accept that information right here. It's going to be a contact number to get in touch with him so you can form an actual contract. This is what they're doing with the court cases. They're selling off little bits of the court cases to private investors. It's called shredding, and I've got it right here. Pay attention. It says offered and received. They put a score on property. State's exhibit. They put a score on a state's exhibit. I put a CD in. I put that video in. Defendant's exhibit. One DVD. 227 investments. Offered and received. Now, again, I can't say that's exactly what it is. It represents a value of something. But they were fulfilled. 67. We go through this 143, 143, 145, 145. Oh, here's one. 151 offered, but they received 152. 129 were offered, but they received 130. See, there's some inconsistencies that I want to have audited on this account. See, there's an accountant that will certify this and saying it's true and accurate. But I see some balances that aren't quite balanced. And I want them balanced. So let's find out. All kinds of questions we can ask in regards to this stuff. But you can see there, this here, the state's exhibit, photograph. These are photographs they took of the scene and stuff. And then the DVD, which is the officer's DVD, the paraphernalia. They took my property. They took my property and are claiming it as state's exhibit. And put it up for sale. Offered it. Then they have clerk's record, which is SC or SRCR. And then the AGCR. They've got clerk's records of a couple other cases here that I don't see on any other records. They're not naming these specific cases by these codes. These are three different that they're. I don't know what they're saying. I don't know what cases they're referring to. Evidently, they're not included in the rest of the transcripts. What are these? How do they relate? What is their relative? Do they have a next of kin? What's their chain of title? I have serious questions. What is the original and genuine source? Lab report. Well, if it's a lab report, is it a state lab report? Are those two different? Do I need to get this lab name and get a DUNS number on that too? Yeah, I'll do that if I need to. Photographs of defendant. No, they didn't take photographs of the defendant. The defendant is known, and you can check this with any English major, the defendant is known as an abstract noun and cannot be possibly realized. The defendant, you can never taste the defendant. You can never hear the defendant. You can never see the defendant. You can never touch the defendant. You can never smell the defendant. It will never come off of that piece of paper. The visual aspect is not the defendant on piece of paper. It's a different observation. Not in legal form. Unlawful conveyance. Simulation of legal process. Arrest history. First time you're arrested, even if you don't have a driver's license or anything. Say you're 17. Say you're a minor. Say you're a minor and you're not able to contract yet. They want your social security number. They want a social security number in lieu of. Because they can't get it from a minor. So they have to go to mom and dad. And they can't charge mom and dad. So they have to get a social security number in lieu of. So think about this stuff, people. And remember, once again, I'll be back with some more videos. I'm going to pass this on to Derek and tell him to pay attention to the end of this one. This was the shred part. They are literally shredding the case and selling the different elements by offers and receiving. If they're offering, what are they offering? Is it some kind of transfer of information? Is it transfer of the actual substance? What? Is it a warehousing? You know, you'll see the same thing on the inmate release documents. Again, things that I refuse to find or refuse to sign. So think about this stuff, people, and realize what you're doing when you're signing. What kind of signs are you giving? Are you reading between the lines, comprehending what they're not saying, while saying that his intent is to proceed as if though it's a voluntary, willing, consensual waiver of a trial by jury, when in fact there is no such evidence on the record? Is he making a legal determination and then advising that to the state? I mean, who the hell is doing what here? Isn't the plaintiff state the one that's supposed to be making their demands, and I'm supposed to be making my demands, and he's advising the state to do what? Sounds like a legal determination to me. Again, people, comprehend. Pay attention. Again, like myself, I went into this knowing that I might get into trouble, knowing that I may not know things, but knowing that somehow I would come out of it just fine. My interpretation of being just fine certainly ended as though that officer would just leave me alone alongside of the road. However, it's encompassed so much more. And I want to pass that on to everybody. So please pay attention. Most of all, to how it pertains to yourself. Do your own research. Don't listen to me. Don't believe me. Comprehend what's going on with what they put before you. As I said, they had me all circled up in that courtroom. I thought I was an intelligent man. I was going to be able to circumvent all this. Circumvent it did. Yeah, okay. Look at me here today. I'm asking you guys to hit a PayPal button. But be it as it may, like I said, it's all worth it. It's all worth it. Because, again, regardless of whether you guys hit that PayPal button, I'm going to continue doing this. As long as I have a means of doing it, I'm going to do it. So if one day all of a sudden I drop off of here and you don't find me anymore, listen for me. I'm still going to be singing it. Meantime, again, remember, God bless. I love you all. Have a great night. Bye.